Dobry wieczór and good morning to everybody. On behalf of CourtWatch Poland Foundation, I have the pleasure and privilege to welcome you on our webinar about justice through internet with Judge Roy Ferguson from Texas and Paweł Lewandowski, attorney at law at Domański-Zakrzewski Palinka firm. Ladies and gentlemen, this meeting is hosted also thanks to help and support of US Embassy in Warsaw. So big thanks to our friends at the embassy. And this meeting is translated to Polish. So let me firstly switch for Polish just for a second to explain how to turn on the interpretation. Szanowni Państwo, bardzo serdecznie witamy. Na chwilkę przyłączam się na język polski, aby szybciutko wytłumaczyć wszystkim uczestnikom, że macie Państwo możliwość wyboru języka, w którym będziecie słuchali naszego spotkania. Na dole menu tego oprogramowania, którego używamy, czyli Zoom, znajduje się przycisk Interpretation z ikonką globusa. Klikając na niego możecie Państwo wybrać angielski bądź polski. Całe spotkanie będzie się odbywało po angielsku, natomiast będzie tłumaczone symultanicznie na język polski. Więc jeżeli Państwo sobie życzą słuchać dalej spotkania po polsku, bardzo polecam przełączyć się na język polski w menu. So I'm back to English now, and I can introduce our guest a bit more. Judge Roy Ferguson sits at 394th District Judicial District in Texas. So as you probably all know, Texas is the second largest state of the United States, twice the size of Poland, and with a population of 30 million people. And Texas has a similar structure of state judiciary. It's 3 tiers. And Judge Ferguson sits in the district court. There are more than 400 district judges in Texas, and it's something similar to our circuit courts in Poland. So this is a general jurisdiction court, trial court, first instance, and Judge Ferguson hears both criminal and civil cases, divorce cases. To let you know how what are the conditions of Judge Ferguson's work, let me just tell you that the district that he's presiding, and he's the only judge in this district, is the size of 3 Polish voivodeships, so 1/5 of the Polish soil. With on the other hand, just 30,000 people living in this region. And he's the only district judge for this region and for this population. This part of Texas, the western Texas, is also known for biggest national park in the United States, the Big Bend National Park, on the side of Rio Grande River, because the part of Texas Judge Ferguson is working is on the border with Mexico. What I found interesting, while doing research on the district of Judge Ferguson, was that when I looked at web pages of the counties that are included in your district, I've noticed that every time the most important building there pictured in the website was the courthouse. So I believe that judicial branch is really important for Texans, and you're a really respected profession when you work.
Well, I appreciate that. Thank you for the kind words. It is very rural. You're right. A lot of land and not a lot of people, with a lot of driving before, of course, the pandemic struck and changed everything.
Yeah, so it's a pleasure to have you here, and we also have Paweł Lewandowski. As I mentioned, he is attorney at law at Domański-Zakrzewski Palinka. He's recognized in both global and European chambers rankings for dispute resolution. And he's a co-leader of dispute resolution practice of that largest Polish law firm. So thank you, Paweł, for joining us, and thank you for sharing that you'll share your experience in all hearings in Poland. So let me start with you, Judge Ferguson. What I'm sure is interesting for many attendees here on this meeting is of course what happened with the cat. I mean, how the hearing where Mr. Rod Ponton appeared as a cat, how it ended up. Was he saved, or was he, I don't know, maybe punished with a fine?
You know, you have just touched on one of the most important things about presiding over or participating in virtual hearings. And that is the demeanor of the court and the patience of the judge is of greater importance than it even was in person. When you are in person, you have the grandeur of the hall. You have the majesty of the courtroom with high ceilings and the big bench, and everyone's looking up at you. And it becomes clear when the bailiff tells everyone to rise and fall silent that you're in charge and that you set the tone. But when you're in Zoom, it's just what you see here. The only difference is I'm wearing a black robe. Everything else is exactly as you see it. So the majesty of the courtroom comes from the demeanor of the judge. And you're dealing with people who don't have a lot of experience using this kind of format. And everyone's nervous. And my belief is every single person who enters a courtroom is nervous. Every person wants to do their job as best they can. They have a great responsibility, whether it's the court to do justice or the lawyer to protect their client or the client whose liberty or family is at risk. They're all nervous. And so we must heighten our patience and be kind to the people who are in there. Now, Mr. Ponton had been in a couple of hundred, I would say, a few hundred hearings with me over the year during the pandemic. And while we were accustomed to him having technological difficulties of some kind, that was a new one for all of us. And you will notice that at no point in that video clip that I snipped do you see his face or mine. And that's because I didn't want to embarrass him. I didn't want to embarrass him at the time. And I still to this day don't want to embarrass anyone. I remained calm. I didn't laugh, which meant the other lawyers didn't laugh. Everyone remained professional. And when I stopped that clip, what I did at that exact moment was come on camera. And I was in the robe and I was in my judicial mode. And I said, Mr. Ponton, you know, got his, because he was in a panic, right? Yeah. He didn't know what to do. And so I met the cat's eyes and said, I want you to click on the up arrow next to the video button. And I want you to go into the video settings. And I told him the two things I thought it could be. And it was not 5 seconds before it was gone and his face appeared. And we went straight into the hearing with no comment and no mockery and no discussion. And we had a meaningful hearing on this civil case. So think about how that could have gone. He did not get embarrassed. He did not get punished. I did not get angry. And when it was over, the entire world watched that 48-second clip and said, you know what, maybe this will work after all, because that could be me tomorrow. It was him today, but tomorrow it could be me or my partner that happens to. And everyone was put at ease. Look how nice that went. The judge didn't get mad. No one got in trouble, and the system continued to function. But if I had gotten mad, if I had held him in contempt or embarrassed him, the reception would not have been what it was, with everyone laughing. It would have generated a discussion about judicial abuse, about the technological ineptitude of lawyers, and it would have spun off into a very negative discussion around the world. You know, 2.3 billion people have seen that video. And far beyond 99% of the comments have been positive. Above 99%. I challenge you to find any video where 99% of the comments worldwide are positive. And this one did that. So that's how it ended.
Yeah, we all love cats, that's for sure. And that's what that's what was a very, very uplifting video. That, you know, not only me have those technical glitches with the technology. So I'm curious, is it common that you have to help parties or attorneys that come in front of your court?
It is. It's every day. It is now a part of our job, and it is a part of everyone's job who's watching this, whether you're a lawyer or a judge. I don't know who our audience is primarily made up of, but I assure you that part of your job is now helping people get into the courtroom and helping them feel like they've had their day. That's what we call it in Texas. You've had your day in court. Now, the worst thing you can do is have someone come in on something that they have been preparing for and stressing over for a year and walk out feeling like they just got run over. It's important for the system to function, which in large part functions on a fiction. Remember that we don't have guns. We don't have the army. They obey our orders under this fiction that we have the authority to order them to do these things. And that falls apart if people don't trust that they were heard. And so part of your job as a lawyer is to make sure your client is prepared and your witnesses know what to do. And then our job is to help shepherd the lawyers and the self-represented parties to make sure they know what to do, so that at the end of the day, you get 94% of litigants, as we have in our polling, that say, I had a fair hearing in my virtual hearing, and I don't feel like the outcome would have been different in person. Now, that's what we see in our polling, and you'll see the same thing, so long as you accept that part of your job during this time is not just doing research and writing and arguing, but it's also shepherding people into and through the system.
That's an attitude that I really admire. But isn't that you have, you know, assistants, you know, IT, you know, guys helping those people and also training you all the day long?
I have none of those things. I have 5 extremely rural and poor counties that cover 56,000 square kilometers. So I have one person that I work with. She is my court coordinator, and she also serves as my digital bailiff because we don't have the money for a digital bailiff. And she and I are the IT department, which is why I had to know how to get the filter off of the cat. We do everything. There are cities that have armies with all of the money they have. They have oil and gas money, or they have a population of 5 million taxpayers. They will have a briefing attorney and 2 digital bailiffs and an IT department. But I can tell you from experience, I think that makes it tougher, to be honest. You need to know how to do these things yourself so that you don't rely on someone else to keep your court functioning, or if you're a lawyer, to keep your case moving forward. Now, there's nothing worse than saying, Judge, I can't figure out how to get that document on the screen. I need to bring in my 18-year-old receptionist who knows the computer better than I do. You don't want that to happen. So we do it all ourselves, the 2 of us, for our thousands of hearings, and it works that way.
That's really inspiring that you can handle those things, and that you really want to know these tools by yourself to feel safe. That's an interesting perspective. And I would like to ask you, Paweł, what were the changes that happened during the pandemic in Poland with, you know, actually representing your clients in the court? Are the online hearings as popular and as smooth as we can hear from Judge Ferguson in Poland as well?
Yeah, I must say, from week to week and from month to month, I can see that the online hearings are more and more popular. I remember the days when I switched the first online hearing, and all we in our law office were very, I would say, nervous and skeptical how it will run. So you must imagine that the judiciary, but also the lawyers practicing litigation, arbitration, belong to the most conservative lawyers, yes, because the whole judicial system is rather conservative and rather reluctant to learn all this new stuff, all these new technologies. So from day to day, we have to learn very, very quickly how to work online in this online society. At the very beginning, I was thinking that the hardest piece of cake is the technology, how to learn learn Zoom, how to learn MS Teams, how to exchange the documents, our reviews, how to organize the whole connection in order that it works. But after some weeks and months of experience during these pandemics, I would say that the most important factors in the online world of litigation arbitration is fairness and patience, as Mr. Ferguson said. Yes, because we are always learning from hearing to hearing how to function in this world. So this requires the patience on both sides, on the side of the judge, but on the side of the parties too, because everyone is new in this world. But on the other side, what is very important is the fairness and the mutual trust of the attorneys towards the judge, but also of the attorneys among themselves. Because let us imagine the situation that we have a witness already cross-examined, and this witness is confronted with a, I would say, troublesome question. So one can imagine that in such a situation, this witness can switch off the camera, switch off the connection, and is out, yes, because he needs some, I would say, advice of his attorney, etc., etc. So we have to learn also the confidence and the mutual trust in order to avoid such situation. And what is quite promising for me, that in neither of the cases I had experience with, we had such situations. So we had maybe some thoughts that witnesses are somehow, I would say, trained or etc. But it had never happened that someone, that an attorney or a witness, I would say, torpedoed the court hearing. So this is quite promising for us, and I think it's those two factors, rather, I would say, from this psychological part of the story, and not from this very pure technological stuff, is the most important factors we have to follow.
Mm-hmm. Thank you, Judge Ferguson. I imagine that it's something similar that you mentioned before, that the respect and the kind of atmosphere that you try to have on your online hearings are close to what you usually have during your traditional hearings. But what I'm curious about is it that you can handle all kind of cases online, including even jury trial? How does it work?
I have handled every kind of case, including 7 jury proceedings, with the exception of a felony criminal jury trial, felony being the highest level of crime that we have here under Texas law, because our emergency orders by the Supreme Court require that both the prosecution and the defense must agree to a virtual jury trial because of certain constitutional rights that we have embedded in the 6th Amendment of the Constitution that give a defendant the specific right to look their accuser in the eye. And we had a big debate about whether that would include here, because I'm looking you in the eye right now, and you're looking me in the eye right now. But our courts have said, that's not what they mean. My interpretation, in a snarky way, has been apparently the right to face your accuser includes the right to smell your accuser, because I can see your face. But because of that, it requires mutual consent. Civil cases, family cases do not. And so we have forced those jury trials on people. I have not found any kind of a hearing that I cannot do and feel as though the outcome would have been different in person. Mm-hmm. I did poll all of the lawyers who appear in my courts, and I believe that the number was again in the 90s when asked, do you believe the outcome would have been different in person? Mm-hmm. I believe 90+% said never or rarely do they feel like it would have been different. And from a profession who always feels like if we lost, we were cheated, we always should have won, that's an astonishing admission by the bar. Yeah, and I agree. It does not feel different. The only examples they give is, well, I had a case one time 25 years ago where the person stumbled on the way in the door, and I felt like the jury seeing that really gave them a glimpse into his injuries. Well, that's great, but I've done over 1,000 hearings and trials in the last year that, based on your one anecdote, would not have gone forward. Mm-hmm, mm-hmm. And the vast majority of lawyers feel like the benefits of being able to take the witness's face and blow it up into a screen that's 42 inches wide far outweighs the negative impact on judging credibility of not seeing them from the waist down.
Okay. So I think it's different in Poland, Paweł, isn't it? We can handle just the civil cases via internet, isn't that so?
Exactly. So the civil cases are allowed to be held on the online hearings. The criminal matters not, because of the specific and I would say more conservative, more traditional approach of the criminal law, but also because of the necessity to observe some human rights in the criminal proceedings. But civil cases, so in a broad meaning of this scope, so also labor cases, etc., can be potentially held on the online hearings. The same with the administrative matters. By the way, the administrative courts are now working only on the online hearings, and plus some hearings in camera, so no classic hearings. So the civil cases are absolutely allowed to be held in online.
I've noticed that some of our attendees are already asking questions. That's great. I think the first question that was put there, Paweł already answered. But if you have any other questions to our guests, please feel free to ask them in the comments section. You can ask them in Polish and English. I think we'll save some time in the end of the webinar to ask those some of those questions to our guests. So feel free to use the chat in our meeting. Judge Ferguson, we have faced this shift to online hearings in a really rapid pace in Poland. I'm sure that was the same in the States. The pandemic was something that really changed the circumstances, and everybody had to adjust in a really quick manner. And one of the things that was a matter of, and actually is still a matter of controversy, is the publicity of the online hearings, because these cannot be accessed so easily as traditional hearings by simply coming to court and just sitting in the courtroom. But rather, they are more hard to be accessed. How you handle this thing? How you handle the right to public hearing?
We have the same rights here, both the United States Constitution, the Texas Constitution, and the United States Supreme Court, which is the one you all probably hear about on the news. You don't hear about any of the lower courts. They have all agreed that we have transparent courts. We don't have secret courts in the United States, with a very rare exception. And so we had to be transparent. What we do is, those of you who use Zoom know that Zoom now has a built-in feature that lets you live stream to either Facebook or YouTube. And so all of Texas courts who use Zoom for the last year live streamed their hearings onto YouTube. what we have found is we have greater transparency in our courts than we have ever had before. The objections that we got to YouTube streaming were varied and very interesting. Number one, we had judges saying, well, I don't want anyone to see what I do. And we said, well, they've always had that right. And they would say, yeah, but no one exercised that right. No one came to court to watch. And now I've held hearings and had thousands of people watching. And our response to that is two things. Number one, the fact that someone doesn't commonly exercise a basic fundamental right does not mean you take it away when they do start exercising that right. The opposite should be true. You should cherish it and foster it more when people start to use it. We need education about the justice system. One thing we've learned in the United States in the last year is a lot of people don't understand how our Constitution really works. I'm not going to go into politics, but you've seen it, what we've gone through in this country as people have been fighting over what they think the law actually means. And by and large, they're very, very wrong. So most of the time, we are live streaming to YouTube, and I still live stream every hearing. I'm in the middle of a trial right now on recess to join you today, and that has been live streamed all morning and will be live streamed to the conclusion of the hearing here today. I saw a question pop up about closed trials. There is a way that you can restrict the public consumption of certain information if that information is of such heightened sensitivity, or if it's legally protected as confidential or privileged. And if the lawyer can establish and meet that burden for us, then we must take the least restrictive means in order to protect that information. That does not mean closing the courtroom. In the United States, you can't just kick everyone out and lock the door because you want to as judge. That's automatic reversal, no secret court. So what I would do, for example, if I have a child that is too young and the parent says, this child's going to testify about sexual abuse, and the child is 6 years old, then I could turn off the child's camera for the public and just let them hear the voice. Or if there were photographs, for example, that depict certain body parts of a person or a victim, then I would have those distributed on paper rather than shown on the screen. So the participants can see it, but the people watching the hearing on YouTube can only hear us talking about those. We cannot close it unless the Supreme Court says we can, and that's not ever going to happen. So we have a workaround that puts the burden on the lawyers to prove that we need to grant some protection.
So it's the question also addresses an important issue, I think, and also the situation that we were discussing in the beginning. I mean, the appearance of one of the attorneys as a cat is something that wouldn't happen, offline. It wouldn't happen in a real courtroom, of course. And it also points out to some other security issues, I think, that people might raise. I think that if attorney can turn to a cat, the technology in the future might be sophisticated enough to turn this person into an attorney that would be pretending to be representing someone, or to pretend to be a witness that you want to hear. But actually, it would be a so-called deep fake. So digitally converted picture, so it could look and sound like another person. Do you feel that it's there's something to be afraid of regarding these technologies?
Afraid, no. Aware, yes. And by the way, insofar as no one would ever appear as a cat in the courtroom in person, you would not believe some of the things I've seen in the 9 years I've been doing this job. I've had people come in and remove a coat and have a bikini top on, or a shirt that says something bad message to the court with foul language. We've had people bring their pets in. I had someone swing a machete that they had hidden over the heads of the jurors during a case. That was a lawyer making an argument. So crazy things happen always, no matter what the format is. With respect to deepfakes, as that technology advances, so will the protection. Think about computer viruses. As computer viruses are created, so are the computer virus scanners and protectors. So I know that technology is out there. But every one of us, I've been doing this for almost 30 years as a lawyer. We've all seen faked documents. We've all seen fabricated text messages over the years that someone is always trying to fool us. Part of our job is judging credibility and making determinations of authenticity. So I've had photos that have clearly been faked, but I study. I go to conferences like this one, and I learn what to look for so that I can identify those fake documents. We will do the same with the deep fakes when they start to proliferate. They're not there yet. We can tell. There are ways to know. Same thing with a green screen. I've had someone try to pretend in a photograph that they were in a particular location, and you can tell when there's a green screen behind someone, no matter how good it is. So don't be afraid of technology. The future is coming. I mean, it took us less than 100 years to fly the first airplane and land on the moon. Technology is advancing very, very quickly. Don't be afraid of it. Be aware of it and keep yourself educated on the cutting edge of technology. Like we said earlier, if I were not my own IT department, then I would not be able to recognize some of those things, but I can. And that's my advice to everyone, is be aware.
Pavel, could you tell us how does it look like from the perspective of clients? I mean, are they aware that their cases will be held online, and are they happy about it? Or maybe they have some thoughts, that it's like a second quality justice or something. How they do react to this change?
I don't think so. I would like to say that the clients start seeing also some cutting of costs, yes, because also traveling to some remote courts in Poland from Warsaw for a holiday or even 2 days is connected with some costs on the clients must bear. And I would say this is also it allows to limit the costs and to save costs, and what the clients can see that. And also from the perspective of the clients and the witnesses, the clients appointed witnesses, they see they can see also some transparency and also some easements how to participate in the hearings. I have also I am in the middle of the long-lasting hearing in a local court in southern Poland, and we have also a in-house lawyer being an appointed attorney, and he takes part in every hearing. I would say just like to listen to the hearing, not to be active. And in a normal circumstances, he would never participate in such court cases, because he would say it's a matter for us, for the attorneys. And thanks to this new technology, he can really listen and somehow control us how we lead the case. So from the client's perspective, I would say it doesn't matter. I would say it's even more positive than the negative, and absolutely it's not treated as I would say second-class litigation, something more, I'd say, worse and maybe not very transparent. And maybe some words to some few remarks to the transparency of the court cases and how it should be made available to the audience, to the public. I think the prejudice and the reluctance of the Polish judges is the same as the United States, yes, because transmitting the trials through YouTube, it means from the formal point of view the same as the classic court cases, when I would say potentially an unlimited number of participants can enter the courtroom. surely in the, I would say 90 or even more, 90% of the cases, no one is present in the courtroom apart from the judge and the attorneys and the witnesses. But this is the transparency. And I would say it's absolutely possible, at least in Poland, to put some transmissions on some public, I would say, websites or portals. So Polish courts, the Polish judiciary has the official website, the so-called portal of the courts. And from the technical point of view, it's absolutely possible to put a transmission, a record of the transmission there, yes, in order to make it available to the public. So I would say it's even easier to give it public than in a normal way, in a normal way. Although I understand the reluctance of the, I would say, the conservative approach of the ministry, of the Polish Minister of Justice, which is another story for another discussion.
But on behalf of Court Watch Poland Foundation, I can assure you that we would be very happy and very supportive towards publishing the trials online, so people could easily access them and learn how the justice system works, how the law works in practice. And that would be great for the civic society, for civic education. That would be really great. I don't feel that we will see it in a soon future because of some protection of personal data, which is very harsh in Poland and generally in the European Union. And this is the main reason I think we don't have it now in Poland. But maybe there will be some I don't know, I'm expecting things should here change, so to fulfill this right to the public hearing in the times of those Zoom hearings and Zoom courts. We have some questions from our attendees and also from judges from Poland, addressing the issues that we have already touched. But one of the things I think we should also address, and Judge Ferguson pointed that out, is the access to justice. How actually this technological change, this revolution, can change access to justice, because I'm hearing that argument. I mean, this argument quite often, that actually online hearings are bad to access to justice because there are some people that are technologically illiterate. I mean, they don't use computers. They rarely use smartphones. What about them? So I would love Judge Ferguson to address that.
When we first launched this back in March, and you want to talk about sudden, it was overnight. We got a letter from the Supreme Court of Texas that says all courts are closed until further notice, but you can use online means. The next day we were online. It was immediate. But we sat down, a small group of us, as we tried to formulate what this would look like going forward. And we said, what's every fear we have? What's every reason this can't work? And one of the big ones was, we thought, a digital divide. And that's what you're describing. There's a separation between the haves and the have-nots. In the United States, of course, that typically centers around money and race. Mm-hmm. And so they were saying, by shifting online, you're going to exclude the poor mm-hmm. and minorities from participation in the justice system. And we thought, well, we need to watch out for that because we can't have that. Mm-hmm. But we all anticipated that there would be some of that. After 1.3 million hearings, we now have confirmed not only was that fear not realized, the opposite is true. We have greater participation of indigent. We have far greater participation and diversity of race, greater minority participation across the board. It has revolutionized access to justice. For example, in the old days, in the pre-times, if you had a hearing or a jury trial, every participant had to take time off of work or get babysitters, have a reliable vehicle, money for gas, drive in or fly in for court, get a hotel room if they need one for a 15-minute hearing. That just simply didn't happen. And so our jury pools were primarily Caucasian and primarily older people. There was a skewed older with people who had more time, more money, more ability to come to court. Now, we have found the vast majority of people have a cell phone or have a computer or have someone nearby or in their household who has one of those two things. The only people who have to come to the courthouse now are the people who have none of those things. Because what we do is we set up a sterile environment with a tablet and a webcam and a speaker and a microphone. And that group of people who can't find any other way in, they just come to the courthouse. So instead of 100% coming, we have found it's less than 1% of people who don't show up. Our jury response rates are 2 or 3 times greater than they were before virtual hearings. My virtual jury panel, I could see 60, 70, or 80% response rate. And in the old days, it was 15%, 25%, far greater response. And the best way to summarize it is with child welfare cases. Now, in Texas, the government, if it meets this extremely high burden that the child is in danger, can take your child out of your home and appoint you a lawyer. And then the court's job is to protect the child and find out who the parents are. A lot of the people who are dragged into that court system, they tell us they don't know who the father of the child is. That is very common. And so they'll say, I believe the child's father is Mr. So-and-so. I think he lives in Georgia, but I don't know. It was a one-night stand. He may have given me a fake name, that kind of thing. Before we had virtual hearings, it was maybe 5% of those people ever participating. They just didn't care. And they weren't going to fly down to Texas for a child that might not be theirs. With virtual hearings, we have almost a 100% appearance rate by alleged fathers. We now have children with parents for life. Whereas 2 years ago, if their case had come to me, they would go through life without ever knowing who their father was. The opposite of your fear is the reality. And with 1.3 million hearings, that's not a guess. That's not an anecdote. That is data-driven fact. It is greater. I have people join hearings from the break room at their job on the other side of the state, wearing their uniform with their name tag and their hairnet. They walk into the break room. They tell their boss, I need 15 minutes. They set up their smartphone, which everyone has in the United States, and they appear right there. I've had doctors who would have cost $10,000 to testify, pop in from the break room in the hospital in their scrubs and masks and testify for 15 minutes and leave at almost a zero cost to the parties. People are getting more evidence in. There are fewer people defaulting, meaning not showing up because they can't afford a lawyer or travel. We're getting better outcomes because we have more evidence. And what we want is evidence to do the right thing, right? That's our job, is to do justice. The more evidence, the more participants, the better our results are, the better our decisions are. So it has improved all aspects of our system going forward.
This is really great and encouraging. I'm sure that the similar process we will observe in Poland. Maybe it's not with this quick pace that you have mentioned. 3 million hearings, online hearings, was it?
Texas has had over 1.3 million.
1.3 million.
In Texas.
Just in Texas. So the new technologies are not only, Zoom, but also social media. They, raise all sorts of emotions. And we also observe that, they are pointed as kind of a source of all evil now, and this political polarization and things like that. And this is a matter of kind of controversy, whether especially not only lawyers, but especially judges actually should use social media, and if they should or can use social media, what for? So I know that you're active on Twitter. I don't know about other platforms, but this video with the lawyer cat video was published by you on Twitter and gained this attention. But what was your motivation to actually open this account on Twitter? And do you have any like personal rules about what the judge can actually write on Twitter or what he can't? Because it's kind of, different situation. You're not a private person, even if you're on Twitter.
A judge is always a judge. In Texas, our judicial ethics, the canons is what we call them, the canons, they apply no matter where I am or what I'm doing. If at my child's baseball game, if I'm at a bar, or if I'm in the courtroom, they apply the same. And in fact, punishment is typically greater for a violation, for an ethical violation in public, rather than in the courtroom. In the courtroom, 5 people see it. On Twitter, the world can see it. And so if I did something unethical on Twitter, I would stand to be punished far more severely than I would if I said something stupid in chambers to one lawyer in private. We need to let people know that the judiciary does not see itself as different, all right? The only difference in the United States between a judge and a lawyer is that the judge got elected or appointed to a different job. We are the same people. I've been a judge for 8 years, 9 years now, and I was a lawyer for over 20 years before that. I'm still the same guy. I'm just doing a different job. And so when we talk about ascending to the bench, I don't know if that's a phrase you use, but when a lawyer becomes a judge, they call it ascending to the bench. It's important for people to know that the ascension is the steps up to the bench, not floating up to the heavens on a cloud, right? We're still the same people that we were before. And Twitter has allowed us to communicate in a professional way with the public, and we use it to educate. I use it to educate. My goal when I got on Twitter first was just to watch, and because I knew I was at great risk. Judges here are elected. We're by and large storytellers. We tend to want to be the center of attention. That's how you get elected for things. And on social media, if you do that, you're in trouble. You are bound to get in trouble if you try to be the center of attention. And so my job was to watch and learn. And then I realized what I could or couldn't do. The temptation to be Roy and weigh in on political issues or on off-color humor is very strong. And so I had to wait until I had the ability not to do that. And once I had developed that thicker skin, then I decided that I would use Twitter to uplift and to educate. And if you go on my Twitter feed, one of you, I'm not sure who runs the Twitter feed for Court Watch, but I know you see what I do. If you go through my Twitter feed, you'll see most of it is either something uplifting or is specifically about court or both. And that's always my goal, is to uplift people while educating about the justice system, the judicial system. That's where the cat came in. The initial post about the cat lawyer was telling people, this is a new problem that I've never seen before. Here's how you need to be aware of what it is. And then I said, it also exemplifies the fact that lawyers are still working hard and putting their egos at risk by continuing to see that the justice system is working. So my rules for judges on Twitter are, number one, in the United States, do it. Connect with people. 2, never be political. Never, ever comment on politics, because there are 2 things we can't do in our ethics. 1, we can't do anything that lessens the dignity of the office we hold. because we are always the judge. So that's number one. Number two is you can't say anything that would lead someone to believe they have an edge in a hearing. So if I were to come out, for example, and say, I think capital punishment should be abolished. Well, I have just told everyone that you should come to me for that kind of a case because I'm not going to put your client to death, right? Same thing with abortion, same thing with parental rights, same thing with visitation and access, same thing with whether people should be forced to pay in certain circumstances. If we advocate on social media, we have educated people on how we're going to rule, and we call that bias. We call that the appearance of bias or impropriety. And if you do that, you will either get sanctioned or you will get removed from cases just by them hitting print and handing it to the presiding judge. Judge Ferguson has already told us he's biased. Here's his tweet. So if you avoid those things and just talk in an educational and uplifting way, then it's valuable.
Thank you for that. That's really interesting insight in your also Twitter activity, and this education, comes along all the time. I know that you also run mock trials for children. I know that you all this sort of stuff. That's really great, and I admire that. We also help as a foundation judges to run things like that. But we have some more questions regarding this online hearings, and one of them I think might be interesting for Paweł as well. Maybe could you please answer us first, Paweł? Do you feel that there is this risk, and how you would answer the question regarding the possibility to manipulate the testimony of the witness when it's given online, not in the courtroom? Is the risk higher? How you judge that?
Yeah, the risk at first glance, the risk can be higher, yes. So because one can say, yeah, we have the witness out of our controls. There is a guy sitting in a separate room. We can see only his face, is how he is speaking. So maybe on his screen or just like close to him is someone sitting and telling him what he should he or she should testify. But first of all, what I mentioned at the very beginning, this is the fairness and confidence and the mutual trust to the attorneys. Yes, so I have never seen that in my short online hearings career that a witness is manipulating on somehow supported by someone else. You can use some, I would say, tricks in order to minimize the risk. So, for example, you can ask the witness just like to turn off the camera in order to see the room, what is like on his or her desk, etc., etc. You can even imagine such operations, like, for example, you have a commitment with your with the attorney from the opposite part to send, and I would say a guy or an attorney or an attorney trainee to the opposite witness in order to control physically the witness, yes, already testifying. So these are some tricks how you can minimize such a situation. But I would say if we have a mutual trust to our opponents, yes, and we are really fair, such situation will not happen, yes, or will be not as abused as you can imagine. So this is quite promising for us personally, that from the side of my opponents, which are also from honorable offices, I have never seen such a case of manipulation.
Judge Ferguson, is your experience similar, or do you face, someone trying to manipulate your lie more often by being on camera?
Well, people who are going to lie are going to lie. It doesn't matter whether they're remote or in person. They're going to lie if they're willing to lie. Paweł is exactly right about that. There is an honor system that we rely on. That being said, it is incumbent on the judges and lawyers to improve their perception skills. I have caught people trying to cheat, but it's easier to catch someone cheating than it is to catch someone lying. Because, you know, if someone is sitting like you are, and I don't know how to say your first name or your last name without screwing it up. So why don't you tell me how to say your name?
It's Bartosz.
Bartosz. Boy, I'm glad I didn't guess. So you're zoomed way in on me. I can't see your hands. I can't see your lap. But Pavel, I can see his whole upper body, right? So I'm watching you very carefully during your statements and your testimony. And when someone's going to cheat, they're going to do something like this, right? That's not how you look if you're looking at the clock. If you're looking at a clock, you just do this number. But if they're cutting their eyes to a person, they're gonna surreptitiously glance. As soon as that happens, I'm on you. I'm now watching everything. I'm watching the shadow on the wall behind you, or the shadow here. I'm watching for lighting to change under your chin. I have caught people on their phones. Of course, we all know this look, right? Well, that's really easy to catch. But I caught someone one time. He was great at it, but the lighting under his chin kept changing. And I finally said, "Sir, I know you've got electronics on your table. Put it away." And he went, "Fine," because he knew he was caught. I've seen shadows fall behind on the wall in the corner, which means someone's moving around the room. One of the best ones we had was a baby's arm came into frame. In a child custody case, the child was in the room, which is a big no-no in our courts. And this baby's arm reached across and picked up the stapler and went out of frame. That's happened twice. One time I had someone wake up a witness who fell asleep in the chair. He was about 90 years old, and he just slowly faded back like this. And a hand reached into frame and shook his shoulder and snuck back out, which means that the witness in the next room was watching the live stream. And when I brought him in, I said, "I saw you wake him up. I know you were watching." And he admitted. What's he going to say? "Yes, I was watching." I said, "You're excluded as a witness." So it is very hard to get away with cheating. And if you were cheating, Bartosz, I would say, pull away from the camera. I want to see your whole upper body, just like I see with Pavel. And if there's a document like I see there, I'm going to say, "What is that document over there? Why do you have it?" "Oh, well, my lawyer told me to have it." "Is it face down?" "Yes." "Leave it face down unless I tell you otherwise." So, you know, it's a matter of training and of awareness and perception. And you should actually hope that you can catch someone in your case cheating. Because boy, oh boy, you want to make the judge mad? Catch the other side cheating in the hearing. We will exclude the witness and their testimony, and then you're going to see some fireworks. So it is a concern, but it is an easily manageable concern for the participants in the courtroom.
Okay, thank you for that insight. We are 5 minutes after our time. I'm just watching on the clock because I know that you're heading to your courtroom to actually have a trial, isn't it so?
That is true. I have a few minutes if we want to take questions, but I am in the middle of a one-day bench trial on the appointment of an administrator for the estate of someone who died. It's a very interesting case. It will be going from about 1 hour from now. So we have about 1 more hour for our lunch break. And then it goes for about 4 hours. It is live streamed and deleted. So you can't come back tomorrow when you wake up and watch. You either watch it live or you will never see it, just like in the courtroom. If you like, I can share the link to that page so that anyone who wants to lay in bed, have a cocktail and a nightcap and watch some of the hearing, they're welcome to do so.
Something better than Netflix, maybe.
I don't know about that, but you know, the lawyer cat can happen at any time. So you never know what's going to happen. There's this, I just put the link to my main page in the chat. And once we go live again, it will show the video and then you'll click on the video to see it.
So for all you interested in watching this trial, Judge Ferguson gonna preside in an hour. The link is in the chat window, so you can easily access it. And for the future, I have noticed that you have a web page of your court. Are the links to YouTube transmissions, live transmissions published on the web page, or we should rather look for your YouTube channel, your court's YouTube channel?
They are at the bottom of the main page. You'll see the icons for Twitter, YouTube, and maybe Facebook, although I don't participate much in Facebook unless it's campaign season. Facebook is more community discussion, and that does not lend itself well to judicial notices. So if I have a trial, I'll put it on Facebook just to say, don't forget, you need to come to court. But Facebook is a little too angry and a little too political in the United States. The temptation is too strong to weigh in. So I stick with Twitter and YouTube exclusively.
Too many things to waiting to be commented. Paweł, thank you for all your insights. Do you have anything to add at the end? Maybe answer a question from the chat menu, maybe something you would like to add at the end?
At the end, I must say that the movie of Mr. Ferguson was very impressive. So maybe showing it to the third time, it's better than to the first, because you can discover some. I would say this is something what was quite obvious when I was hearing right now to Mr. Ferguson. So this openness and fairness to the parties. So this is, I would say, the clue of the judiciary. What I miss here in Poland, that the trial is somehow the feature, some kind of a feature where the judge sometimes wants to tell us, to the attorneys, yes, and sometimes he seems to be too close, too confident to the parties. And I would say this mutual support between the judge and the attorney, it's absolutely key how to facilitate the trials, not only here in Poland but worldwide, because the litigation or the trial is somehow it's a support from the state to the parties, because the parties wants to the court to buy something. It's more or less, I would say, it's a market. It's a market where the participants wants to have a judgment to be clear in the situation, and to facilitate this kind of trial is something what we have to learn worldwide, I think. So
thank you. And Judge Ferguson, any last word before trial and saying goodbye to our attendees?
Well, I would be absolutely remiss if I did not thank and apologize to Robert, our interpreter, with a presentation. We call them continuing legal education, CLE, but with a presentation of 1 hour on a topic that is so vast, I knew I was going to have to go quickly. And I was keenly aware throughout that I was taxing Robert in his speed of interpretation. So Robert, thank you very much. And I apologize for the number of words that I forced you to translate in a very short period of time. For the rest of the attendees, don't be afraid of remote hearings. You're going to find, as you do them, that there are great benefits you can reap from remote hearings that you simply do not have in person. Your clients will be better served many times through a remote proceeding than through traveling to court for an in-person proceeding they may wait all day and never get to. So just accept that this is part of your profession going forward. Don't resist it. Don't get angry about it. Simply accept that this is part of the deal and start learning and start honing your skills remotely in your presentation in a box, the same way that you would when you would fill the courtroom and try to shine in front of the judge under the big overhead lights. So once you get to that point, it becomes very easy to say, I can be better than everyone at this, the same way I think I'm better than everyone in the courtroom, and serve my clients well. So that's what I would leave you with. Thank you for inviting me. It's been a wonderful honor to cross the pond and spend some time with you here today. So thank you again.
It was a pleasure. Thank you for your time. Thank you for your insight and sharing with the experience you have. Thank you, Paweł, also for joining us. Sure. That was a very interesting conversation, and I'm really happy that we could meet and learn more from your expertise. So for all the attendees, this meeting was recorded, and I think it will be published in a couple of days on our YouTube channel. So if you like to share it with someone that you know that struggles with online hearings and what to think about them, I really recommend to listen to our guests and rethink the issue. So thank you very much once more, and have a nice trial, if I can say that. And have a good evening to everybody, and have a good day, Judge Ferguson. Thank you one more time.